Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Honorable Supreme Court of India, 3 judges bench, Justice B.R. Gawai, Vishwanathan and Arvind Kumar. In the case of Shambhu-bhai, Raisingbhai, Padhiyar versus State of Gujarat, in SLP number 9015 by 2019 on 17/12/2024, reduced the death sentence to 25 years of life imprisonment. This is clearly 25 years of life imprisonment. Why? Because of the report given by, it's called Project 39A report, where there is likelihood of reformation on the part of the accused. So since there is likely reformation on the part of the accused, he was given the life sentence. This is the beauty of reformative theory. That's why I am making this video. Let us go into the facts of the case. Of course, Honorable Supreme Court of India, considering the possibility of reformation as per behavior and mental assessment report, so reduced the so-called death sentence. Right. The appellant, that is Shambhu-bhai, his name is very lengthy. Shambhu-bhai allegedly, actually, he has taken away a child, that is a boy of 4 years age, on 13/4/2016 around 11:30 a.m. on the pretext of buying an ice cream for him. After buying the ice cream, he took him to an isolated place where he committed the so-called aggravated sexual assault on the boy, and since he was under the impression that the boy may divulge information, killed him. So it is a case of rape and murder. We cannot say rape, sexual assault and murder of an innocent boy of 4 years. That is the case. It so happened that in this case, PW10, that is aunt of the deceased, actually she saw the accused, or she saw the deceased in the company of the accused. Questioned him also as to why, where you are taking him. The boy said ice cream. No, why you are going for ice cream? Come back. But the boy did not hear, and this fellow took him away. Ultimately, dead body was traced. So on that same day, there is no gap also. Around 3 p.m. or so, the parents of the deceased were in search of him, and when they came to know that this accused person took him for ice cream, caught him, thrashed him, and ultimately the fact was known that the body was also seen by 5 p.m. itself. The post-mortem examination was conducted on the next day. So very fastly the activities, the actions took place. Basing on the evidence of PW10, I believe her number is PW10 because I have seen the judgment. She has categorically stated, and actually she withstood the rigorous cross-examination also. PW10, yeah. She remained unhindered during the cross-examination. The time frame was very, very advantageous because there was no delay. Judge believed and awarded death penalty to the accused person. Second point, whenever we discuss the Pocso Act, please remember the provisions of section 29 and 30. Section 29 is very, very important because it gives a presumption that the accused should prove that he was not guilty. That is, burden of proof shifts on him. Right? 29 is very, very important. And here the judge discussed 106 of the Evidence Act also. That means when a fact is known to any person, he should prove it. Here, definitely he is when he alleged that he was not at all present on the spot, burden is on him to prove that he was, it is a fact that he took the deceased person for buying ice cream. ఇది వాంట్ చూసింది కదా, చూసినప్పుడు ఐ డిడ్ నాట్ కమిట్ అఫెన్స్ అనేది బర్డన్ ఆఫ్ ప్రూఫ్ షిఫ్ట్స్ హిమ్, బట్ హీ కుడ్ నాట్ గివ్ ఎనీ proper explanation. He could not explain as to what happened after he spent time with the child. కేవలం నాకేం తెలీదు, ఐఎమ్ ఇన్నోసెంట్ అంటే కుదరదు. ఇక్కడ 106 ఎవిడెన్స్ యాక్ట్ అండ్ ఆల్సో సెక్షన్ 8 కూడా చెప్పాడు, దట్ ఈస్ కాండక్ట్. బోత్ ఆఫ్ దెమ్ వర్ సీన్ టుగెదర్ ఇన్ ఐస్ క్రీమ్, దెన్ హీ వాజ్ అలోన్ ఫౌండ్. It shows the subsequent conduct of the accused person also. So please remember, in the very famous case of A.N. Venkatesh and another versus State of Karnataka, Section 8, that is a previous and subsequent conduct of the accused was also taken into consideration. Right? So basing on the mitigation investigation report or Project 39A, which stated that, number 1, the accused is or the appellant is suffering from minor psychological aberrations, and also he is having the tuberculosis. Second, he is maintaining the relations with mother and his 10-year-old girl child, daughter. His conduct in the jail is good, and actually he is feeling remorse or repentance also for the act done. So therefore, since there is a likelihood of getting some Honorable Supreme Court of India was pleased to reduce the death sentence to 25 years of life imprisonment. Right? So good judgment, read it and enrich your legal knowledge. With this, I am concluding. Thank you very much.